about what you know about this case and why it was dismissed.
Well, I mean, I know what is publicly available. I don't have any particular insights as to what happened in the courtroom. I know it was a case that, a fairly new murder case. It was a 2020 case. And that during the course of the development of the evidence in the case, they discovered that there was a cell phone that they had in their possession. And when I say they, the police department at the very least, we know that the police department had this phone and had apparently done a data dump on it and was able to obtain information from the phone as a result of a cooperating witness who gave them the passcode and everything. And this was a phone that belonged to the alleged victim in the case. And so a defense attorney is going to want to know what's on the alleged victim's phone, particularly to the extent that the alleged victim may have been involved in nefarious activity on his own. So one of the things that we demand and we're entitled to receive from a law enforcement agency and from the DA's office by extension is anything that is considered exculpatory or mitigating. So that comes about as a result of a Supreme Court case from 1963, Brady versus Maryland, which had the holding in it that it's a due process violation for a defendant to not be provided with all evidence, not just the evidence that the prosecution thinks is important. So they are not allowed to make the decision what evidence is provided to a defense attorney. We, as defense attorneys, are entitled to all the evidence, good, bad, or otherwise. And we don't even have to ask for it. They're supposed to provide that to us as a part of their ongoing obligation to provide all the evidence to the defense. And a lot of departments and a lot of prosecutors' offices have made great strides toward making sure that if evidence is not provided, we know why and who's to blame for that. Corpus Christi Police Department, our DA's office, most of the surrounding law enforcement agencies cross-check each other to make sure all the evidence has been provided. They give each other affidavits of compliance that would have some enforcement teeth to them if it turned out that a lead detective on a case signs off on one of these affidavits swearing to the fact that he's provided all the evidence to the DA's office, and it turns out he either negligently or deliberately did not. Now, Brady doesn't make a distinction about that. It doesn't care whether or not it was overt malfeasance or just negligence. It's a due process violation regardless, because the failure to provide the evidence is what invokes Brady. And of course, since Brady, we've had the Michael Morton Act in Texas, which actually involved overt malfeasance, a prosecutor who deliberately withheld evidence of Michael Morton's innocence, and DNA evidence. Obviously, he was not the perpetrator of the crime. And, he went to prison and he spent a considerable amount of time in prison before that particular case was found out, and that DA is no longer a DA. And we have something similar here. We have a cell phone that clearly was not provided to the defense. And at that point, after the trial has started, after a jury has been seated and sworn, jeopardy has attached. A discovery violation at that point in the proceedings really requires that the case be dismissed, because it's too late to fix that problem. And that ruins everything. It ruins everything, because now we don't know whether or not what the outcome of the case would have been, whether or not a guilty person goes free or an innocent person would have been convicted is no longer the issue, because the case is over with. And it's no longer an issue whether winning or losing. It's that justice hasn't been done. And justice didn't get done because somebody didn't do their job correctly. And we know that for a fact. Somebody dropped the ball. It's a question of sorting out who dropped the ball and what remedy is available for that. But the alleged victim's family is left without resolution. We are left without knowing whether or not a guilty person has gone free, or possibly an innocent person would have been facing a conviction that he didn't deserve. Anytime that happens, the entire system is thrown into turmoil. When justice isn't done, we all suffer as a result.
Yeah, and obviously it's not ever about winning or losing, but that must be devastating to a family too, because they never get justice.
closure, anything. And sometimes, you know, there are some families who, you know, Mr. Naranjo's family in particular, he has dodged literally a bullet on this. He has avoided an outcome, a reckoning with the jury. He had a great attorney. The state was represented by a great attorney. Mr. Flores is an upstanding guy. Not a question in my mind that he would not have done anything like this deliberately. So the question is, who dropped the ball and where? And that's one of those questions that may never be answered, because we have too much to continue to do. You know, unfortunately, the time can't be spent, or probably won't be spent, trying to analyze and figure out and avoid this problem in the future, because time marches on. We have other cases that have to be tried, and we have to all do our job about making sure that defense attorneys have asked for and received all the relevant evidence in a case, that the courts have made sure all the evidence is exchanged hands before trial begins, before a jury is selected and seated and sworn. But unfortunately, that's, you know, water under the bridge as far as this case is concerned.
I mean, is that something that's become common here? Or?
It's more common than it should be. It's way more common than it should be. And I know that the DA's office has put some safety checks into place to prevent this from happening. And I guess in any system where you're dealing with human beings, there's always going to be a lack of perfection, and there's going to be that human element. But it seems to be far more commonplace here than it is in other jurisdictions of this size. And one has to ask, what could be done that would prevent this? Because I know the defense bar is organized enough to, you know, we bend over backwards. We're going after everything. We're asking for things multiple times. I routinely sit down with the DA's file and go through and compare their file with my file to make sure that there isn't something that has been overlooked, inadvertently not provided. Obviously, in a worst case scenario, maybe hidden, forgotten, lost. Those things happen.
And for people that don't know what is a Brady, it's a Brady violation, Brady law, what is the term and what does it mean? Okay,
so Brady has to do with the Supreme Court case Brady versus Maryland, in which a capital murder trial was conducted. There were two co-defendants, and one of the co-defendants actually had confessed. And that confession was not provided to Mr. Brady during the course of the trial, and so that was not presented to the jury. And obviously, a confessing co-defendant would be very, very germane evidence for you, if you were going to trial, to be able to show to the jury, hey, guess what, my co-defendant confessed. Now, it may not have been relevant to whether or not he actually participated, but it would certainly be mitigating at the very least. And the Supreme Court held that, you know, denying that evidence, and it was apparently denied deliberately. It was not deliberately not provided to Mr. Brady, and so the holding in that case was denying of that is a due process violation for which the defendant is normally entitled to a rehearing or perhaps even a new trial. And then, of course, Texas adopted the Brady rule in the Michael Morton Act, which is codified in the Code of Criminal Procedure now, which requires as a statute that all evidence be provided to the defendant. And we don't, like I said, we don't even have to ask for it. They have an ongoing obligation to provide that. And every bit of it, the prosecutor, again, does not get to decide whether or not the evidence is relevant. All evidence has to be handed over to the defense. We decide whether it's important or not to present at the time of trial.
Is there anything else you feel like I'm not asking or is important for people to know about, you know, even if it's not this case, just the fact that it's been happening pretty often here than other places?
And a lot of times that is a function of leadership. An office has to be dedicated first and foremost to integrity. You have to want the fact of your cases to be, that the cases are being properly tried, that there isn't a lingering doubt about whether or not justice is being done in the courts. And you can't have that in an environment which is not, does not have integrity as its first and foremost goal. And so the more often that these things happen, the more often that fingers are pointed at individual members of the DA's office or at the DA himself, that again reduces everybody's confidence in the system. And we're going through a crisis of confidence throughout the country right now, regarding the judicial system and the jury system and whether or not we can rely on verdicts delivered by imperfect humans and cases tried by imperfect humans. You know, how do we get to the point where we have confidence in the outcome of a police investigation, a district attorney's office handling the indictment of the case, the appointment of competent attorneys to represent the individuals, and then the outcome by a jury which is fairly and impartially selected to hear the evidence and to carry their duties out to a verdict that we can all rely on and not have to second guess. It's not easy. And a break in any of those links is a downfall for the whole system, unfortunately.
And because of double jeopardy, he can't be tried criminally for the same crime again. Could he be tried, like, could there be a civil case with this, or how would, you know?
Well, sure. There aren't the same set of rules for civil cases as there are for criminal cases. I mean, a civil case can be, except for some very narrow issues regarding what's called res judicata, a civil case can be tried any number of times. A criminal case, once jeopardy has attached, the double jeopardy clause of the Constitution prevents him from being retried. Which is great for him. It's not so great for the family of the alleged victim because we don't know what the outcome would have been had the case been tried appropriately or developed appropriately and provided to the defense counsel in a timely manner. But you know, finding that out, it's happened to me before. During the course of a trial, suddenly a witness is talking about evidence that you've not seen, that the prosecution has not seen. The whole thing comes skidding to a halt, and the court is left with the option of trying to figure out what can happen. You've got the jury in the box. They've been sworn. Jeopardy has attached. So how do you proceed in a trial like that without doing harm to both the defendant's rights and the whole process, the whole system? You can't. A judge is left with a very, very unsavory job of having to either declare a mistrial or, as happened in this case, relying on the prosecution to do the right thing and to dismiss the case, acknowledging the shortcomings and the failures.
Anything else?